Welcome to the Personal Injury Law Show. This show that talks about everything current in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of over 25 years' experience. With me tonight, I've got a partner in a law firm in workers' compensation, John Karantzis. Good evening, John.
Hi, Tony. Hi, viewers.
And Steve Notarianni, an associate in a law firm in workers' compensation. Good evening, Steve.
Evening, Tony. Evening, all.
Tonight, viewers, have got a very interesting show that talks about the pitfalls at work. That's trips and falls at work. So stay tuned for that.
However, Tony, before we get to that, what's in the news?
John and Steve, this is the most extraordinary story I've seen this year.
Yes.
They say that footy clubs and, in some instances, coaches are supplying the drug ice to their players to get better performance. Is this outrageous or
It's
what?
a shocking story, Tony. Regional, suburban football clubs in Victoria, the players as young as 14 years old, Tony, are on ice.
Steve, it's amazing that, I don't know where they got this from, because if it wasn't accurate, you'd think people would start getting sued.
Well, that's exactly right, Tony. I mean, there must be some sort of basis.
No, there is. There is, Tony. There's reports about young players as young as 14 years old. They're on ice. They want to feel like superhuman on the field.
Okay, why don't we look at it this way? Apart from breaking the law, these coaches and whoever's supplying the drugs,
Yes.
can't they get sued for the damage they're causing these young people?
Oh, I think exactly, Tony. I mean, you look at the coaching situation, for instance. I mean, they're in control of the team, the influence they have over these people, and you know, it's remarkable to think that we're actually dealing with junior teams also.
It's a criminal offence, Tony, and not only that, the health of these young players.
Yep.
So who would you sue? Would you sue the coach and the club?
Most likely the club, because they've got insurance, Tony.
But surely the coaches would get sued as well, wouldn't they?
You'd think so, yes.
Anyway, let's keep moving. Oh, well, John, this is right up your alley.
Oh, yes.
Exton may sue. What's this story about?
Tony, this goes on, you know, the issue of drugs in sport, the Essendon saga. It's going to come to a conclusion, isn't it, Tony, pretty soon?
It's going to come to a conclusion soon.
34, the Essendon 34, Tony. There's 34 players that if they're found guilty by ASADA, they could all issue Supreme Court proceedings the day after in negligence against the Essendon Football Club and the AFL, Tony.
Well, Steve, the AFL employs these players, so they're in the gun as well, aren't they?
Oh, they definitely are, Tony, as the employer.
And there's at least 4 or 5 players that have gone to other clubs and they've already said that they're going to sue.
Yes.
If they get found guilty. I guess it tarnishes their reputations.
Oh,
and in
yes.
some players' cases, endorsements, they could lose those, couldn't they?
Oh,
John?
yes. These claims are worth millions and millions of dollars, aren't they, Tony?
Oh, they might be. It depends on what the losses are. Plus, also, I guess it tarnishes these players' careers into the future beyond football.
Oh, it certainly does. It tarnishes their reputation moving forward, which can impact on, you know, endorsements, media roles, etc.
Opportunities.
Post-football. Yeah,
Loss of reputation, future contracts, if any, and also, Tony, and this is vital, their health.
Yeah, for sure.
That's been
But
affected.
we'll never know that. I mean, this is a little bit like asbestos. It could take 20, 30 years.
Well, that's
It'll take a while.
The health is the unknown
manifest.
factor moving forward. We don't know
It'll take
into
a
the
while.
future how long,
So
what the effects will be.
Our advice, Tony, would be, of course, that all these Essendon players should be seeking legal advice as to their entitlements.
You'll stay tuned. We'll keep you updated on that. Psychiatric hospitals are bursting at the seams. What's this story, Steve? This is bizarre.
I think it's to do with the overcrowding of the psychiatric facilities in Victoria at the moment, Tony. I think it's a reflection on where society's heading and the onus that's been put on our hospital system and psychiatric hospitals in particular.
John, we had this incident recently of the young girl that was murdered.
Yeah.
It sounds like there's a lot of people out there that probably do need treatment of some description.
Exactly.
And if we don't have facilities for it, it's going to cause major problems moving forward.
We have to make sure that these hospitals are fully staffed, the resources are there, Tony. There's a lot of psychiatric patients out there that need care, and these hospitals are bursting at the seams, literally. Not only the psychiatric hospitals, Tony, but as we all know, the normal public hospitals.
Yeah, it's becoming a massive problem.
It's a massive problem, and also, again, the issue of ice is at play, isn't it, Tony?
Well, there's ice, there's all these other drugs that people are taking, but apparently the Thomas Embling Hospital in Fairfield it should only be catering for 40% of the people it's looking after at the moment.
Yeah.
So there's obviously a massive shortage.
It's a lot.
It looks like society needs a lot more help in that regard.
Oh, yes.
Anyway, look, we should really get someone from the mental health services to come along and discuss this issue, because it seems to be a massive problem in society. Trucking deaths preventable. John, coroners found that 3 people with these tip trucks, they've hit power lines and died in the space of 4 months. Doesn't that seem like such an innocuous situation?
And that's the problem, isn't it, Tony? Our coroner, Audrey Jameson, found that in 2006, these deaths to these workers were preventable.
They were, and it's amazing that the tip trucks, they hit overhead power lines. You'd think that an experienced driver would know that lifting your tip truck and to the height of power lines.
Oh, exactly right, Tony. For someone that has worked in that industry or that field for an extended period of time, you would think they're up to speed with safety procedures, mechanisms, etc. It's remarkable to think that we've had, I think, 3 within a relatively short space of time.
Well, it sounds like there's inadvertence, probably a bit of complacency.
Exactly.
Maybe working under pressure. Who knows?
Yes.
It's hard to say. It's very, very sad. Let's hope that...
It's just another example of where the employer can't take shortcuts, Tony.
No, training, I guess.
And that too.
Although, really, you'd think the individual would be wary of power lines.
That's right. I think it comes down to the individual, and at the end of the day, taking their own precautions. You mentioned sort of mere inadvertence. You just need to be on your guard.
But having said that, the employer's still got to do a risk assessment, don't they, John?
And appropriate training.
Yeah. They just can't wash their hands of it, Steve.
Oh, no, that's right.
Viewers, we've got to go to a sponsors break. Stay tuned. After the break, we'll bring you up to date with trips and falls at work. Viewers, welcome back to the show. Today we're talking about the trips and falls at work and the pitfalls of working in areas like trenches, on boats, all sorts of things. The important thing the viewers should know is that at the workplace, the onus on the employer is a lot higher. They've got a non-delegable duty of care to ensure that the workplace is safe, and also the employer's got to do risk assessments. They've also got to give guidelines and training. Is that correct, guys?
That's correct.
Now, on that, John, first matter I want to discuss is the young worker that died on the 5th of March 2015
Yes.
when a trench collapsed.
Yes, this happened in Cranbourne East, Tony. A young worker in his early 20s was working in a trench at least 4 metres deep, and suddenly, what we understand, the trench has collapsed on him and he's died thereafter.
Steve, he was 19 years of age, so he's very young. He wouldn't really know much about safety at that age, you wouldn't think. And, if you're working in the trench, obviously, sometimes you take shortcuts thinking, it's only a 4 metre trench.
Yep.
But things happen pretty quick, don't they?
Oh, they happen very quick. For a young worker, relatively inexperienced, obviously heavily reliant on the employer to ensure that adequate safety precautions have been taken. Unfortunately, the fact of life is that often shortcuts are taken.
John, what are the rights of the family in this situation?
And that's where we've got issues of, were the appropriate measures taken in precautions, Tony, in safety, in ensuring a safe workplace. Now, Dependency claims are available to any family members that were dependent on this young man's wage.
That is if he had a spouse or...
Anyone
If it
that's
was in-
dependent upon
okay.
him. And if he had children, young children, again, you know, pensions are available.
What about nervous shock? Would there be nervous shock claims available to family?
I think certainly under the WorkCover scheme, no. We're looking at statutory
The Wrongs
benefits. It would be a Wrongs Act claim.
Just on this issue of trenches, guys, there's another accident that happens in Sydney, in a building site in Cherrybrook, Sydney's northwest. What happened there, Steve?
In this case, Tony, we had a 47-year-old worker who died after a collapsed trench at a building site. Similar, I guess, circumstances to the one we've previously talked about in Cranbourne East. I think it was a plumbing business.
He was the head of the family plumbing business,
Yep.
Tony. Again, he's in the trench, which has collapsed. Now, again, you've got issues of, well, who has conducted the safety audit?
Well, these trenches, I mean, it sounds like you dig a hole, right?
It's an accident.
Don't you have to put some sort of barricades up to stop this
Exactly.
I would
collapsing?
think so.
Exactly. It's if it's not done properly, Tony, it's an accident waiting to happen.
And I guess you're 3 metres deep, which is what, 10 foot, right?
Exactly. Yes.
So when the soil collapses on top of you,
Oh,
you
it's
die from what?
asphyxiation,
asphyxiation.
Okay.
and you're crushed.
I think, Tony, you can also differentiate this second case from the first in that you're now dealing with a 47-year-old worker, so someone that is far more experienced and yet is still subjected to the failings.
It's a question of whether or not, Tony, safety standards, are they slipping?
Well, it sounds like, you know, they're taking this for granted, doesn't it? Yeah. And here you would have someone that's probably got family, would have probably a spouse and kids,
Exactly.
so they've got the right to sue. But look, we've got to pick up our game, don't you think? It's just bizarre how this is happening on such a regular basis in similar sort of
And
circumstances.
employers have to be aware that you cannot abrogate, you cannot say, I'm not responsible for this. You are responsible, it's your own building site. Even if you have subcontractors working on the building site, the builder is responsible for that building site.
It's a non-delegable duty of care.
It is, Tony. That's a good point that John makes, that often on a building site you'll have different subcontractors on site. It is the responsibility of the operator, of the builder, who's in control of the site, to take care of the relevant safety precautions.
And apart from the civil actions, there's also likely criminal proceedings there.
Oh yes, the builder could be prosecuted under the criminal provisions of the WorkCover legislation, Tony, for criminal manslaughter.
All right, viewers, look, we'll come back to those stories in due course and let you know what happens. Steve, give us the facts of this interesting case of the Lander and Sydney Ferries Corporation, 2014 New South Wales decision.
Yes, Tony. Look, this was a case that involved a worker who was a deckhand with a company in New South Wales. He'd operated or worked on a certain ferry for an extended period of time. On this particular day, he's working on a different ferry. He trips on a step on this different ferry and suffers a significant injury to his foot. He issues proceedings or lodges a claim for compensation and ultimately is successful in that claim on a negligence basis.
Let me stop you on that. John, he's actually tripped on a raised still forming part of a doorway
Yes.
as he approached the cruise mess area.
Yes.
So what are we talking about? Something...
Oh, literally,
Would it be-
Tony,
No.
it's the break between in the doorway, and I think we've all seen it in ferries, Tony. These raised sills, and the issue, one of the issues, the main issues here was there's different heights in different ferries.
Yep.
He thought he was working on his usual ferry. The problem being he actually wasn't. He was working on another ferry which had a different height of seal.
So he got confused as to what ship he was working on.
Exactly.
Or which boat he was working on.
His evidence was, I usually walk on my normal ferry and I know instinctively how to adjust my walking pattern when I see the seal coming up. In this case, the seal was higher than usual because it was a different ferry, and that's why I tripped.
Yeah, but I mean, the average person out there would say, Why don't you watch where you're going? I mean, let's be realistic. Isn't that the obvious?
That actually was the argument put forward by WorkCover in New South Wales.
Okay.
A failure of keeping a proper lookout, Tony.
Well, there was a couple of questions that were asked of the court.
Exactly.
The first one was, we've already discussed. The second one, should the employer have marked the step in a distinct way to draw attention to its height in circumstances where the steps varied heights throughout all Sydney ferries? And the third one, did the employee fail to take sufficient care for his own safety, which is the contributory negligence argument. What did the court find in this, Steve?
Look, the court found that there was no contributory negligence on the part of the worker. The court talked about situations where workers are familiar and with their workplace, but the court referred to, I guess, momentary inadvertence or inattention, and decided that that does not found a basis for contributory negligence, that it's accepted that in cases where workers are performing repetitive work or repeatedly working in the same environment, that there will be moments where they are not paying attention, in effect, and the employer must take account of that.
If you'll stay tuned, we've got an interesting twist in this case. We'll discuss it just after the break. Viewers, welcome back to the show. We're talking about this interesting case of a fellow that fell over on the ship. He missed the height of a step. What's really fascinating about this case, John, is on contributory negligence. There was evidence led that he might have been in a state of inebriation or alcoholised, Steve.
Yeah, look, he was, I think, a known heavy drinker, Tony. So it was suggested, I think, on the part of the defendant that that had contributed to the incident. But in the end, the court's finding was that there was no contemporaneous evidence to support any allegation that he was under the influence or affected by alcohol at that time. So it was dismissed.
And John, speculation doesn't work in the courts, correct?
No, it needs to be proved.
Were you surprised by the result in this case? No contrib? You know, him saying that he thought he was on a different ship?
Oh, look, it's a very interesting judgment, Tony. We've got a situation where he readily admits that he thought he was on a different ship. However, the court found that mere inadvertence will not go against him in this case, Tony.
And Steve, were you surprised by the result or a good result?
Look, I was surprised that there was a finding of no contributory negligence at all, Tony.
All right, Hudspeth and Scholastic Cleaning and Consultancy Services, 2014 Victorian Court of Appeal decision. What are the facts of this case, Steve?
Yes, Tony, this case involved a cleaner at a school. She was in the process of cleaning a toilet at this particular school. The process wasn't going so well. The tools that she had for the task, by way of the mop and rinse bucket, were not doing the job properly. There was excess suds in the area, and she contacted her supervisor, advised the supervisor of what was going on, and was effectively told by her supervisor to simply do the best you can, effectively. So she then goes back to complete the job, slips, falls and hurts her back and a hip, and subsequently claims compensation in a matter that ends up before the Supreme Court and a significant award of damages in the worker's favour.
John, this comes back to the thing that we said before, where the employers can't just leave the worker to their own devices.
Exactly.
They've got to set up a system of work. Is that correct?
System of work, and where they're on notice that there are issues about that system of work, if any, well, they need to advise, they need to guide the worker. All right, this is what you do in these circumstances, and not leave them to their own devices. Which is what occurred here, and that's why the poor worker here, the poor lady, was injured. It's a very interesting case, Tony, because when it was first run before a jury, the jury found no negligence. However, on appeal, it was overturned because of the remarks made to the jury by council acting on behalf of WorkCover, Tony.
Okay.
Now, they were very inflammatory remarks, and it was remitted back to Justice Dixon,
Yep.
who found in favour of the worker in negligence, Tony.
Well, I mean, once the work was believed that the supervisor said to her, do your best, and there was no advice about the safe way or approach to take,
It's very flippant.
you'd think that the worker's in a pretty strong position.
Exactly
Don't you
right.
think?
I think the worker was in a very strong position at that stage. There was a lack of any specific instruction or advice by the supervisor that she turned to. And I think the duty is on the employer to provide the appropriate advice. It's not good enough to simply tell a worker, go and try your best.
You know what's fascinating about this, John? They've never been encountered with a similar problem like this before. She considered that she hadn't realised the proper advice would have been to hose out the area because they had not dealt with a liquid soap spill cleaning problem in the past.
Yes, that is extraordinary, Tony.
It just highlights employers can't just say to workers, hey, go and do whatever you think's right.
And
That's
Tony,
right.
again, this is a perfect example of the breach of the regulations.
Oh, of course, of course. And there's a lot of regulations out there these days. The Occupational Health and Safety Act and the regs, they're massive manuals about cleaning, lifting weights, repetitive work. It covers just about every conceivable aspect, isn't that correct?
Exactly, Tony. Not only employers out there, not only do you have duties under the common law, but you also have duties under the OH&S regulations.
Statutory duties.
Exactly.
That's right. Justin Dixon in this matter found that the employer had breached 2 of those regulations.
Let's go into this case of Green and Secretary, Department of Education and Communities 2014 New South Wales decision. Steve, you want to give us the facts again?
Yes, Tony, this is involves what we would call a journey claim, in that we have a worker who is on her way to work in the morning, arrives at her place of work, and it's a shared office building in the Sydney CBD. She's in the foyer area and she suffers a fall and injures her wrist and ribs in this fall. She brings proceedings in New South Wales. At first instance, her claim was denied. On review, that decision was overturned and she was awarded compensation.
So Steve, what was the issue here?
Well, the issue was whether she had entered the workplace or whether the WorkCover legislation applied as yet, because had she crossed the boundary, I guess, as to where her place of employment commenced.
She had walked into a part of the building that was empty.
Yes, that's right.
Of the employer.
So the issue was she at work or
Was
not?
she at work or not?
Yeah.
Tony, we're talking like 10 metres either side could have changed
This
this
is
case.
almost like, you know, the high water mark there.
Exactly.
You know, those cases in relation to constitutional law.
Yes.
It's
Well,
weird, isn't
in
it?
this
That's
case,
right.
the court found that being in the precinct of the building was enough to say that you're at work.
That's right. Being in this common area or the common foyer of the building was considered to be sufficient. The fact that I think she worked on level 9, she hadn't obviously reached level 9, but she was inside the building, and that was considered to be the commencement of her workplace.
All right, we've reached the end of the show, guys. Steve, thanks for coming on board.
Thanks, Tony.
Thank you,
John,
Tony.
as usual, thanks for coming.
Thank you,
Viewers,
viewers.
thanks for watching. Go to our website, Facebook, Twitter, YouTube. Go to our past episodes. Stay tuned for future episodes, and always remember to stay safe.